Welcome back to our discussion segment. Now, the Jamaica Apex Court, the Judicial Committee of the Privy Council, the JCPC, is changing how it handles appeals. Yes, it says it wants to reduce the number of cases it has to deal with. And so the UK-based High Court is introducing a new rule called the Review of Merits Appeal. Now, this means that instead of having all the judges looking at an appeal, only one will check if it's worth considering. To shed some light on the implications and significance of this change, we're now being joined by legal expert Dr. Lloyd Barnett. Welcome, Dr. Barnett.
Good afternoon, everyone.
Now, Dr. Barnett, please explain for us in simple terms what the Review of Merits Appeal rule proposed by the JCPC entails and what it means, therefore, for appellants seeking justice.
Well, you say proposed, but as far as I know, that rule has existed for a few months now. That has been brought into effect without any consultation with the countries which still have the Privy Council as its final court of appeal. In fact, I'm aware of an appeal from Trinidad in which a ruling has already been made that the appeal is without merit by a single member of the Privy Council. So that this is something which has been implemented already without any consultation with our governments, and it affects our constitutional rights because in our constitution, certain matters give you a right of appeal to the Council, to our Majesty in Council. And this is really reducing the right which is given by our Constitution.
What, therefore, does it mean for appellants who are seeking justice? I know you mentioned it was without consultation, so does that have any more implications for countries like Jamaica?
No, it just means that if you send an appeal there, a single judge, who may be the most junior judge in the Privy Council, may not even be a regular member of the panel, who is assigned this task, can say that there is no merit in the appeal. And, it clearly has a great impact upon the constitutional rights which you previously enjoyed.
Well, since we're in this aspect of the discussion, pray tell if you could elaborate about the constitutional implications. And just before we get to that, how different is the merit-based appeal procedure different from the judicial appeal procedure?
Well, both are judicial appeals. You call it merit-based because what it is saying is that the appeal has no merit. And what has happened is that it has been sent to a single judge, probably by the clerk of the Privy Council, who thinks that it should be so treated. So he refers it to a single judge of the Privy Council, who decides that it has no merit. And so it will be dismissed by reason of the decision by that single judge.
All right. Well, Dr. Barnett, if you could just allow us, we're on a quick break and we'd like to discuss more of the implications and benefits, if any, to be had from this major change by the JCPC after the break. So do stay with us. Welcome back to CVM News at noon. We are discussing some changes that recently took place as per the UK-based Privy Council, Jamaica's final court of appeal, and we have dissecting those changes with us. He is on the phone. He is none other than constitutional attorney and scholar, Dr. Lloyd Barnett. Welcome back, Dr. Barnett.
Okay, thank you.
We talked just now ahead of the break about some constitutional implications. Would you mind shedding light on a few of those?
Well, it is fairly simple that our Constitution regards the constitutional provisions as so important that it gives a right to appeal to the highest court on constitutional questions. It's not in the discretion of the court. When you go to the Court of Appeal and ask for leave to appeal to the Privy Council, it's a formality if it deals with certain things. And that includes disputes in relation to constitutional questions. And what I'm saying is that this modifies that constitutional right because it says that a single judge of the Privy Council can say that there is no merit in that appeal, and it is dismissed on that basis.
I don't know if you had a chance to examine some of the potential advantages or disadvantages of this rule change, but what would you say are the most potent ones, the ones that jump out automatically to you?
Well, there's no doubt about it, is that your right of appeal has been greatly modified. So the disadvantage is clear, that your appeal will now be treated in a very summary way, as distinct from previously when you had the right of full hearing, and so that it will be disposed of on paper by this ruling that it has no merit. And there are cases in which when an appeal begins, the judge thinks there is no merit, and at the end they come to the view that there is merit, so that this summary method of dismissing an appeal of importance is concerning.
So, Dr. Barnett, how do you propose that Commonwealth nations like Jamaica treat with these constitutional concerns?
Well, I think the authorities should say that this is unacceptable because it is modifying the rights of our citizens. And fortunately for us, we have the alternative of going to our own court. We have a Caribbean Court of Justice.
I was just heading there. Perhaps this is fuel to get closer to the CCJ?
Well, I hope that people understand what the relationship is like, in that an important decision like this is made without any full consultation with the judiciary of Jamaica or the legal profession of Jamaica. And I think this is most unfortunate.
Well, thank you so much. That was attorney and constitutional scholar, Dr. Lloyd Barnett.